Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. For more information on any of the stories discussed in this month's update, download our news in document using the link shown on your screen now. In Good Life v Hall Fire supplied a fire suppression system. Their quotation referred to its standard terms, which had a very wide exclusion clause for losses. Some years later, there was a fire at Good Life's premises, which was alleged to be due to Hall Fire's equipment. Good Life sued and argued that Hall Fire's exclusion clause was invalid because it had not been incorporated into the contract and was unreasonable under the Unfair Contract Terms Act, particularly as the general nature of the clause excluded liability for death and personal injury. The court dismissed Good Life's claim and stated the terms had been referred to in the quotation and were therefore incorporated in the contract. Whilst the exclusion for death and personal injury is unlawful, that did not mean that the exclusion for property damage was not valid. The parties were both SME businesses with equal bargaining power, and the court was therefore reluctant to interfere with the agreed terms. The clause was not unusual or onerous, and the losses could easily have been protected by insurance. We reported on the Wood v Capita case in 2015 when it was heard by the Court of Appeal. Now, this case concerned Capita's purchase of a motor insurance business. The purchase contract included an indemnity to protect the buyer if there were subsequent claims or complaints made to the regulator for mis-selling. After the purchase, Capita identified that there had been mis-selling, so it self-reported the matter to the regulator and made a claim against the seller. The Supreme Court has now upheld the Court of Appeal's decision that the words of the indemnity did not cover self-reporting, so Capita's claim failed. The Supreme Court clarified that the court's approach is not restricted to the literal words of the contract. It will consider the commercial common sense when the words are ambiguous, but stressed it is difficult in the tug-of-war of commercial negotiations to judge why the parties have reached a particular decision. Contracts often contain clauses that require a party to use best or reasonable endeavours to do something. A recent case has challenged whether these clauses, without more clarity, are enforceable or void because of uncertainty. The court determined that they are enforceable and that the courts will make a value judgment on whether the obligation has been met. So to avoid being in the complete discretion of the court, it may therefore be better to specify in the contract the criteria that needs to be achieved. We've frequently reported on the General Data Protection Regulation, the GDPR, over the last year. Due to be implemented in May 2018, it will have a big impact for most businesses. Recent developments include the government has issued a call for views on exemptions in the regulations. This closes tomorrow. The ICO has asked for feedback concerning rules about profiling and automated decision making. And the ICO has fined Flybe and Honda for sending emails to customers requesting them to confirm their marketing preferences. Ironically, the emails had been sent as part of a data cleanse exercise to prepare the businesses for the new regime. The gender pay gap regulations came into force on the 6th of April and require large employers to publish gender pay differences by the 4th of April 2018. The data must be published on each company's website and to the UK government website. The final guidance of ACAS and the Government Equalities Office is now available. Whilst many companies are fearful of the stark differences that this may expose, Virgin Money has already published pay gap data. This has highlighted a significant pay gap, but the announcement came with a positive message that it is implementing a bold plan to address the issues it has uncovered. In a recent case, a NHS trust sent a letter making an employee redundant, but there was a dispute about when the notice was given. Was it when it was delivered or when it was read by the employee? Now, the date was critically important as it had a big impact on the employee's pension entitlement. The Court of Appeal stated that for contractual matters, not statutory notices, where the employment contract does not express when a notice is deemed to be given, it will be the date when the employee read the notice. In O'Brien v Bolton Street Catherine's Academy, O'Brien had been dismissed because of her long-term absence for sickness. At the appeal hearing, she presented new evidence that she would be expected to return to work on a gradual basis within weeks, but the appeal panel confirmed the dismissal. The Court of Appeal decided that O'Brien had been unfairly dismissed. Although the evidence of her fitness to work was not available at the time of the dismissal, the court said that the appeal panel still required to consider it. Private class actions relating to competition offences look set to be a regular part of UK litigation. In recent weeks, we've had the decision of a first class action application, more accurately, a collective proceedings order. This case relates to a claim by an estimated 32,000 people for overpayments of up to £200 each on the purchase of mobility scooters because of price fixing offences. The case has been adjourned to allow the lead claimant to amend its claim. We're also expecting the decision on the second class action application on behalf of over 46 million UK consumers against MasterCard. And on the 9th of March, the EU Damages Directive was implemented, bringing with it many additional claimant-friendly measures. Thank you for tuning in for this month's commercial bulletin. We'll be back in June with more of the month's key legal updates.